Welcome. We're glad you are joining us today. My name is Lana Anderson, and I work for the Institute for Human Services, IHS. The training you have selected, Ethical Considerations in Working with Adolescents, is a 3-hour on-demand training. The trainer for this session is Laura Gaines. She's a clinical social worker with nearly 3 decades of experience. She received her Master of Social Work degree from The Ohio State University and is a licensed independent social worker. Laura's career experiences include managing group homes for people with developmental disabilities. She is an associate professor at the Neisinger Center, OSU, family service coordinator at Dahlberg Learning Center, and a mental health clinician for children and adolescents in a private practice. She develops and presents trainings to support the learning needs of human services professionals in the areas of child and adolescent development and mental health, social work ethics, individual and community resilience, and trauma-informed care. Laura is also a volunteer for the Crisis Text Line. Laura, welcome.
Thank you, Lana. So our objectives. First one, describe the framework of ethical and legal guidelines that impact professionals working with adolescents. I'm a clinical social worker, so my frame of reference that I work within most often is the NASW social work guidelines, but this is for all of the guidelines for various professionals that work with adolescents. Describe the importance of identifying the client and your role of the professional in any interaction with a family group and the impact that that has on ethical guidelines. Utilize communication strategies with clients and families to prevent, assess, and manage ethical dilemmas, and to develop a plan regarding professional consultation to address ethical dilemmas. Along with this course is a PDF of handouts. So I printed mine out here. Obviously, this is one option, is to print it out and to write on it yourself. The other option is to look at it in electronic form, but I would still recommend that you have paper and pencil or pen with you. And the reasoning behind this is that the more that you engage with the course material, the more you will retain the information. And our brains remember stuff that we write down infinitely better than stuff we simply read or hear. So when something comes along that really pertains to your work, I strongly recommend that you hit pause, one of the advantages of taking an asynchronous course, and that you jot down that idea or that question, read it back to yourself. It'll help you retain the information a lot more. Another way to help remember information is when you hear something that is impactful or important, that you stop and summarize it in your own words. And then again, read it back to yourself. This increases your ability to implement an idea in a much more effective way than simply reading it or hearing it as we go through the course. And the handout is built so that there's spaces for you to write as it's helpful. Ethics is not so simple. We wouldn't call them dilemmas if they were simple, right? So ethical dilemmas themselves are complex. When we layer in the fact that we're working with adolescents, the complexity gets even bigger. Ethical dilemmas are those situations where there is no exact right or wrong answer. They are impacted by multiple frames of reference, for example, law, policy, culture, tradition, expectations, codes of conduct, expediency, like how can we get this most quickly done? resources, what's available to you, what's available to the family, what's in the community, and then timeframes. Some things are due at particular times, guidelines have to be met. And so they are not simple processes. Working with adolescents is not a simple process. And we'll get into how their age and stage of development, again, adds to the complexity of a given situation, and something that has to be kept in mind throughout your time working with adolescents and their families. One concept that's really important is ethical humility. This is from Reamer 2022, and anything that's referenced in the class is in your bibliography at the end of the handout as well. So you have access to that information there. So what is ethical humility? Humbly reflective social workers, or any other professional, who sense an ethical issue share their concern with supervisors, colleagues, and appropriate administrators. These practitioners do not claim to be ethically omniscient and are not defensive. An effective way to protect clients and practitioners alike is to avoid any suggestion that the ethical issue is being handled in the dark. Such clarity demonstrates social workers' good faith efforts to manage ethical dilemmas responsibly. When appropriate, clients should be included in the conversation. So I want to unpack that quote a little bit. So when you sense an ethical issue, not when you're absolutely positively sure, but when you start to get a sense for like, whoa, I don't know where to go here, or we have two competing demands or two competing rules, or the law says this and the policy says that, and the client wants this, that's when he's recommending that you share your concerns, not when it has all kind of come to a boil. And that you don't claim to be ethically omniscient. Basically, neither yourself nor your supervisor or anyone else claims to be the ethical expert. That you recognize this is a give and a take, and that there's good questions to be asked, different frames of reference to consider, different points of view to look at, and that nobody is absolutely perfect. There are multiple ways to handle a certain situation. There is no one absolute correct and absolute false way. And then the next phrase is, and are not defensive. Well, it's so much easier said than done. This is hard. Sometimes the ethical dilemma is that you've made a mistake. You know, you said something to someone and then realized, oh, I didn't have, authority to give that information to that person. And so part of being humble is recognizing that you're not perfect, that you may not have handled something perfectly, and taking that to an appropriate person to get help. So there's a lot here in this quote. So an effective way to protect the client and yourself alike is to avoid any suggestion that it's being handled in the dark. Again, not this sense of, well, I'm going to take it to supervision and I'll tell you what they say. Like, be more transparent. Share some, again, you have to use your judgment, but sharing information about what is the challenge here? Why are you hesitating? What are the rules and the guidelines that have to be considered? We have a lot more professional knowledge than our clients do. And there's lots of things that they're not aware of that we have to, balance. And so without necessarily telling everybody all of the backstory, it can be helpful to explain some of the complexities to someone. So clarity, showing good faith effort. And the last line, when appropriate, clients should be included in the conversation. This includes adolescents. Again, not an easy call because that's where you come in. So I'm not saying you don't have any expertise, because obviously you do. You wouldn't be working with these clients. You wouldn't have the education or the responsibility you have. So the issue is that you do have expertise, but you are not the final authority on everything. And part of your expertise is figuring out how and when and in what capacity we open the conversation up and involve that adolescent, involve those parents in managing the dilemmas that come along. So when you think about involving an adolescent, this is, to me, it's positive in two ways. So one way is that by getting information from the adolescent, we're learning, we're growing, we are considering another point of view. And then on the flip side, we're helping them learn and grow. But how do you decide? And this is where you look at adolescent development. So I'm going to take two giant steps backwards and talk about for just an adolescent. Adolescence starts when puberty begins. 10, 11, 12, somewhere in there. It is not a fixed status age. It certainly begins before 13, somewhere around eye rolling, I think. So we have very young adolescents who are minors in every sense of the word. They do not have legal authority over major decisions in their life. They have parents or legal guardians who are making big decisions. And at the same time, this is their life. And certainly, as we get into kind of US middle school age, that 13, 14-year-old, kids start making decisions that are literally going to impact the trajectory of their life. Adolescence continues actually into the early 20s. So we've got early adolescence, which is that middle school. We've got mid-adolescence, which is that high school cohort. And then we have late adolescence or early adulthood. And often kids are kids, adolescents are legal adults. So where is your client? What is their knowledge base? How much do they understand about this scenario? How much do they understand about the work that you're doing with them? I have had kids come into therapy who I'm their fourth therapist, and they know confidentiality rules. They've seen how it works in different ways. They have a lot of information about how therapy works. Or a child who's been in and out of foster care may have insights that you don't have yet about how the child welfare system works. So what is their knowledge base? What do they know? Certainly they know themselves and they know their own family far better than you do. Second area that changes dramatically in adolescence is judgment. What is their capacity for decision making? How well are they able to calm down and think through a process? The young adolescent, not so much. High school age adolescents do well when they are calm. But then when the emotions rise, they lose that capacity. And they aren't as good, typically, as full adults in figuring out how to calm themselves down. So what is your client's decision-making ability? And that not only is different in different ages, it's different individuals. And if you work with a given adolescent over time, it's going to change underfoot as you work together. And given that one of our overriding goals is to help adolescents improve their social, emotional, cognitive skills, engaging them in ethical dilemmas when appropriate allows them to learn in a safe environment and increase their capacity. So it is possible that an ethical dilemma will help them move through. So an ethical dilemma that is not uncommon in private practice or in counseling practice with adolescents is when adolescents are talking about self-harming behavior, and in particular, suicidal ideation. So one scenario where I had a client who was talking about harming themselves, talking about wishing they weren't alive, and yet their level of risk really wasn't there where I felt I had the need to, or the absolute authority to break confidentiality and report this to a parent or to a higher level. And rather than struggle with it myself, I realized I was struggling. I was kind of half hearing my client, and I was sitting inside my own head, hemming and hawing about, let me think of this question, let me think of that question. And instead, this was a client who was high school age, adolescent, definitely a minor. That changes things. But had reasonable judgment. And I'd known them long enough to have a sense that they could think things through, they could project out into the future. And so instead of stewing in the dilemma, I decided to involve them in the dilemma. And I just said, hang on a minute, we need to talk about what I do next. And they were like, what do you mean what you do next? And I, the first time I met you, we talked about confidentiality. And so we reviewed that concept a little bit. I said, and we talked about that I would break that if I thought you were at risk of hurting yourself. And they're like, oh, no, I'm not going to do anything. Don't tell anybody. And I'm like, right, except there are some safety concerns here. You are saying things that I'm worried about. And so instead of, and I said, I need you to help me decide what makes sense for you, given the stress you got going on, given how you're feeling, given your relationship. And this is a kid who lived in 2 different households. And so I involved them in that dilemma as to what made the most sense. And the more we talked, the more I had some definite concerns about their safety. And I said, here's what I have to think about. And so I listed out some of the things. You said this. You said that you wished you weren't alive. You said that next week was really stressful. You said that, you've got these exams coming up, and then there's social stress that's going on, and that your family's traveling next week. You won't be here. I won't see you in counseling. What do you think needs to happen in order to best keep you safe? And so now in the end, it's my responsibility to decide, but I want you to help me figure out what makes the most sense. And so we talked through all the options. Did I tell their parent? Did they tell their parent? And in the end, in that case, they were like, oh, all right, why don't you say something to my mom? Because that's who I'm traveling with next week. And we discussed what I would say, how I would say it, my recommendation to their parent. And they said, and tell her not to freak out. And so I said, well, what would help your mom not freak out? And so they talked about, what would help them. So in that scenario, I informed the parent because that's what they wanted to have done. And so the ethical dilemma was worked through with them, as opposed to me making the final decision. And we were both comfortable with it. Trust hadn't been betrayed. Confidentiality was clear. And they and their parent in the end run were able to have that conversation with each other. Now picture a similar scenario, counseling setting, but my client is 18 and a half and very, very aware that they are a legal adult, living home with parent, did a counseling session, talked over what I thought was everything. And then just as they were about to leave, I said, I'll see you next week. And they turned around, looked at me and said, well, probably not. Like, what do you mean, probably not? And at that moment, they shared suicidal ideation with a really high lethality. I was like, hang on, come back. No. You can't just walk out the door. Come in and talk to me. I literally had to step out into the lobby and tell my next client that I would call them and reschedule. And I came back into the room. And by this time, the adolescents' eyes were this big. And they're like, holy cow, you're going to tell my parents. And I said, well, I don't much have a choice here. And they said, I'm 18. I don't give you permission. You may not tell my parents. Okay, you're a legal adult. I now do not have permission to talk to your parent. And at the same time, I cannot let you walk out the door at this high a risk to yourself. So I explained to them that in the case of an adult who is this high of a risk, I had a responsibility to use community resources, to make a call. The town that I was practicing in and that they lived in, I knew that their police department had officers who were trained in crisis response. And I said, so in this case, my option is to call 911 or to call a crisis response team and make sure that somebody checks on you and evaluates, has you taken to a hospital and evaluated. And they were like, no, I don't want that. Just don't tell anybody. Complete transparency. I was like, I can't tell nobody. Like, this is not a scenario that allows me to tell nobody. I have to tell somebody, given what you just said to me. And so again, transparent. They sat down, we went through, I knew they were safe as long as they were sitting there in front of me. So I didn't feel the need to rush the process right in that moment. So we took a good 15 to 20 minutes to process. They were furious. They were angry at me. They were angry at themselves for telling me. They were frustrated. They really wanted to just give up. They were at that hopeless, helpless, nothing's going to get any better. Why won't you let me just do what I want to do? Why do you care? We processed all of that. And in the end, I said, okay, but, and I, again, expediency, I needed to pay some attention to time. And so I said, okay, but at this point, we have to make a choice. So here's how this will play out. I can make this phone call, and this is likely to happen. I can make that phone call, that's likely to happen. Or I can contact your parents directly, and they could take you to the hospital. As I see it, those are my three choices, and I have to choose one, but I'm willing to hear your input. And finally, they were like, oh, just call my mom. Tell her to bring dad and don't freak out and take me to the hospital. Because if you call the other people, then they're going to find out and then they're going to be mad. And I'd rather deal with it directly. So we processed a little bit about that. But meanwhile, I called parents, and in the time it took the parents to drive over to pick up this. And again, this is where your judgment comes in. So you're not the omniscient expert, but you do have to know your people well enough to know whether they're going to follow through. I knew this family well enough, and I felt confident that if I told parents, parents would follow through and take this young adults to the hospital for a full assessment and follow through as needed. But again, involve the adolescent in the conversation, because I felt they had that capacity to do so. Now, honestly, if they had just said no and run out the door, they wouldn't have been available to involve, and I would have had to make my best judgment about how urgent and imminent the situation was, and go from there. And then there are times when you can involve an adolescent. Their judgment is not on board. They're entirely opposed to something that is absolutely necessary for safety, either theirs or else's. And so there are situations where you can explain. I had a client who wanted me to help him convince his parents that he would stop taking medication. Prior to him being on medication, he would go into rages in which he threatened or actually physically assaulted other people and was a risk to himself. And there he was like, it's my right to choose. And I was like, it's the adult's responsibility to keep you and everyone else safe. So in that case, their ability to be introspective, their judgment, their capacity for decision making, their ability to even consider what the long-term consequences are of their behaviors really wasn't present. And so in that case, having a big open conversation, I guess that's the risk. You want to have open conversations where there's room for them. But if you've made a decision and there's no choice here, like, nope, we're going to proceed with this because we absolutely have to, having a conversation in which you ask their opinion about which way to go is false advertising. I guess the best analogy I have for that is if you, it's summertime here while I'm recording this, the ice cream truck is going by. If I walked up to the window of the ice cream truck and they said, we have this and this and this and this and this and this and this, and I said, oh, I want option number 6. And they're like, yeah, we don't have that. Oh, I want option number 4. Yeah, we don't have that. Can I have number 3? No, we don't have that. The only thing we have today are these. Well, why did we have the conversation about options? So if you're in a critical position where there aren't a lot of choices, you can give an adolescent time to talk about how they feel about it, but make sure that that's what you're presenting, not asking their decision. Whereas with that 18-year-old, there were choices. I could call this number, I can call that number, and I can call your parents. Same thing with the younger adolescent who really didn't have the lethality. I could have talked to mom, I could have talked to dad, I could have called a family meeting. In that particular case, the parent who had brought them to session that day was the parent they really didn't want me to talk to. They wanted me to talk to the other parent they had a stronger relationship with. And lethality was not there, that I felt like it was imminent risk and I had to tell someone absolutely right now. So, when you're deciding how much are you going to involve the adolescent, you have to think for a minute there about what are the actual choices so that you're not doing false advertising. Don't ask someone's opinion if there's no way for you to act on their opinion. And the more you can clarify the choices. And in this case, I said to this adult, the 18-year-old, we have 3 choices. We can do 1, we can do 2, or we can do 3. And all 3 were legitimate choices. Now, if they had run out of the building, they would have shrunk that down to 1. But then I wouldn't have been having the conversation anyway. So involving adolescents, I think it's very important to consider, what do they understand about the situation? What is their capacity for judgment? And what is their capacity for making decisions? And in that, you involve them. All right, we are going to move to our next section. And this is Reamer's procedural standards of care. The goal here is for you not just to know these, because a lot of this is standard operating and forms of making ethical decision making. My goal in this section is that we stop and think about, how does this work in your life, in your work with the clients that you see? And so we'll look at these different standard recommendations, again from Reamer, going back to his more foundational work, but also how do you plan in advance so that this is possible? So the first piece of advice is consult with colleagues. Who are your colleagues? When it comes to ethical decision-making regarding adolescents, who are your colleagues? So for some of you, this is as simple as colleague down the hall, the person in the next office, somebody on my team. But I have talked to many professionals where they are the only person in the building seeing adolescents. One professional that I consult with, she's the child adolescent therapist in a building of people who see adults. And so although she has colleagues in regard to therapy kind of in the big picture, she doesn't have colleagues who see adolescents. And there she reaches out to other people. One of the reasons that she and I work together. And so she has someone else to talk about adolescent development, behavior, thinking styles with. And the other way that you may not easily have a colleague at hand is when very specific issues come up. So I had a colleague of mine was working with a family, had established a really good rapport with the family, with the children. The children were neurodivergent, and the mother was like, wow, you are the first therapist they've really worked with. Like, you get them, you understand them, they understand you. This is great. Until the oldest child hit puberty and started exhibiting sexual acting out behavior that was really out of line. And that behavior started to become such that they were at risk of offending against another person. And so the clinician was like, I don't know what to do with this. I have never in my career dealt with this kind of behavior, and it kind of came on fast, and it seems to be progressing quickly. And so the mother was like, well, you'll figure it out. You click with them, you understand them. Ask around to get some information, and then you can come back and tell us what to do. So the clinician made some phone calls, remembered someone that they knew from a conference that they'd spoken to a time or two, and knew that they worked in this area of sexual acting out behavior. So called and specifically stated, I have a client situation I would like to consult with you about. Do you have a time when we can talk for 20 minutes? Set up that phone call. And what the other person said to them is, there's no way you can learn fast enough to solve this problem. This kiddo, given their age, given the behaviors, if this continues on the trajectory it's on, will end up offending and is at risk within a year and a half of being tried as an adult with lifetime repercussions. So no, you can't quickly figure out how to do this. So the ethical dilemma here is, this is my client. The parent wants me to serve this client, but we've got these behaviors I've never managed before. In the consultation, the other professional said, it would be malpractice if you tried to treat him for this. You don't know what you're doing, and you can't learn enough to prevent possibly irrevocable, not 100% irrevocable, but very, very serious consequences. So the clinician went back to the parent and shared basically that information, plus had referral sources to give to the family, and was there to provide support. The parent's response was to refuse. Nope, Nope, we're not seeing anyone else. You're the person that's connected with my kid. You're the only one that's going to be able to help them. You have to do this. Now, in that scenario, the conversation had been solid enough, and the clinician had done enough reading and research that they felt confident telling the parent, I can't and I won't. It would be like asking your pediatrician to treat your child for, do surgery. Your kid has appendicitis. Pediatrician's not going to do surgery on that. They're going to refer you to a surgeon. There are cases and scenarios where you absolutely need a specialist. So in that case, the clinician consulted with a colleague, felt they had solid ground to stand on, and not only made a referral, but refused to continue services with the family so that they could focus very directly on the needs of that adolescent and that very serious behavior. So I want you to think for a minute, who do you consult with? Who could you call in an unusual situation? And this is where networking, getting to know colleagues, keeping in touch with people can be really valuable, because then you're not cold calling out of the blue to get help on a scenario. You're calling someone you used to work with, or you met at a conference, or whose workshop you attended. You've made some connection, so then the consultation is a warm consult. So stop for a second. If you can think of people who maybe you should have coffee with, or send an email to, or even just write down their name and their phone number and what they do, so that should you run into a situation, you can access them without being in the middle of a dilemma when it happens. The next recommendation is obtain proper supervision. Again, you may have this built in-house, which would be amazing and wonderful. And as far as I'm concerned, would be perfect for every, child welfare, mental health clinician everywhere, is if everyone had the supervision they needed and had a supervisor that was able to provide supportive supervision so that it was a safe place to explore ethical dilemmas and situations. But again, this isn't always available. The scenario I described before, if you are the sole practitioner of a specialty, your supervisor may not know a lot about it. They may not be able to provide you with direction and assistance in that area. You may have to reach elsewhere for that. If you are a sole practitioner or in private practice, so I'm an LISW, and my previous counseling work, I practice. So in that case, my supervision was group supervision that I set up with colleagues, and we met on a monthly basis and took turns presenting cases and sharing information with one another. If you're going to do something like that, that has to also be built into your intake paperwork. So my intake paperwork, somewhere in all of the print there, was that information that I participated in consultation and supervision as appropriate for my degree and the work that I was doing, and that I would be presenting information without identifying information unless necessary to meet, safety considerations. So part of operating from an ethical frame of reference is prevention, taking 3 giant steps backwards and building in the scaffolding or the work that you need so that you can do this ethically. So if you are in private practice creating a group, or if you are in an organization where you have to reach out, if you're not getting the supervision you need at work, then you may be able to access it through your professional organization, through like the National Association of Social Workers, psychologists, other licensure boards provide supervision in different ways, some of which you may have to pay for. But again, there's this ethical responsibility that you're not out there doing work without a team to back you up. And the other time that you really, really need appropriate supervision is when you're branching into a new area of expertise. Let's say you want to be that person who deals with sexually acting out behavior. It's a whole new skill set, whole new area of study. And for that, you're going to need appropriate supervision from someone who has expertise in that area so that you can become competent in that area or in that scope of practice. So again, pause for a moment. Do you have the supervision you need? If not, what might you consider as ways to access that for yourself? Either from colleagues, through a professional organization, or through a training program as you learn a whole new scope of practice. Review relevant ethical standards. That's just so exciting, right? If you can't sleep one night, just sit down and read your ethical code of conduct. I know, sounds awful. And yet, we forget all of what's in there. And if you can think through a particular case and read through your ethical standards, it's more interesting than you remember. And keeping up to date with the changes. Every couple of years, every professional organization reviews their standards in light of, most recently, I can think of ethical or changes in the standards because of technology. COVID, working from home. Once upon a time, we all thought you couldn't do therapy at a distance over a video screen, and now not only have people had to do that because of COVID and all the other changes in our society, but research has been done to show that it's effective and it works and it provides people with help. So ethical standards had to change. So reviewing them, keeping up to date. I know NASW Ohio just released in June a review of ethical standards that helps you look at things from a different frame of reference. And then another way to do it is taking courses on a regular basis. I know we're required to do it, but it's also important to do so that you start to look through it through different lenses. Review applicable regulations, laws, and policies. There are so many. Often you will get prompts for this. The agency you work for will say, our policies about blah, blah, blah have changed. Please check your email from this date. Your professional organization will say, this law just got passed and it's going to impact the profession in this way. If you are working with third-party payers, you are going to get, changes in policies. And again, it's just really important to take the time to look through those. And then one way to do that, that's a little more interesting, is to do it with other people. To just read a document can be dry and boring, but if you're in supervision, or if you have a group to say, hey, we just got a new thing, can we read it and talk it through together? So that's another way to review policies. Review relevant literature. Again, this stuff comes across your screen, comes through emails, or if you follow your profession or your area of specialization, you will see information. And as we go, I have information about websites and organizations that in particular look at ethical standards around adolescence. And so reading and reviewing those, not waiting until you're at crunch time and you've got a dilemma on your hands, but keeping up to date so that you have this information in your back pocket and that you've reflected on it so that you have some ideas of how you might use it or address it in your own situation. So here's one organization that can help you look at some ethical standards in regard to child welfare specifically. So the Child Welfare Information Gateway has a section on ethical standards. So for those of you that are working in child welfare, or if you're working outside of child welfare, but you are coordinating with them, it can be really helpful to know the lens that they're working through or that they're seeing things through. And so here's one organization, and these are the topics that they cover. They talk about supervision. They talk about casework practice, talk about confidentiality, which is multifaceted and super complex in the world of child welfare. Client rights. One of the huge questions there is, who's the client? Talk to child welfare workers whose role is that the client is the court, not the child, not the family. The court is their client. And that vastly changes the structure through which they're looking at things. And then the Child Welfare Information Gateway also publishes research on the topic. So when you look at how you review, where do you look, where do you go for information, this is one resource. And that's also listed in your handout. Minors' consent, particularly around sexuality. Talk about ethical, social, legal complexities. The Guttmacher Institute monitors and analyzes legislation, regulation, and judicial actions related to state policy developments on minors' access to reproductive health care and sex education. So they have a monthly update on changes. So if you are working with adolescents anywhere in the realm of reproductive rights, sexual education, right now this is an issue that bears very close watching as different states and agencies are proposing or actually changing laws about what you are and aren't allowed to tell kids, what you can and can't inform them about, what their legal rights are, who can access reproductive care. And when you think about looking at the law, looking at policies and procedures, right now this is an area where there is going to be absolute clashes, where the policy says this, the procedure says that, and the brand new law says this, and then our code of ethics says that. And there is no way that any one of us has the absolute correct right answer for all given situations. So having this as a resource and a place to review potential information to be processed is really, really important. So the Alliance for Children's Rights is based in California and focuses for the most part on California law, policy, and procedure. However, their frame of reference about how they look at things in terms of advocating for the rights of vulnerable children, young adults, and families impacted by foster care is an important lens, whether you're in California or somewhere else around the world. And so this is a good source of information when taking that 2 giant steps backwards to consider ethical rights and responsibilities in situations impacted by foster care. The Juvenile Law Center has a really good document on helping work with youth to advocate for youth change. They have spent years formulating and reformulating their policies and procedures by listening to the voice of youth themselves. And so when you think about how do you help youth advocate for themselves, they're doing this through the lens of amplifying the voice of youth while bringing in the experience and the knowledge base of adults. And so this is a really good reference if you're doing any kind of work where you're wanting to pull in that youth voice on, so what do we do now? How do we change policy? How do we advocate within the legal system? How do we consider what's the next thing to do for our agency, for our system in developing services? They've done a lot of in-depth work and looking at how do we consider that. Sometimes you need legal consultation. Things can get very complicated to the extent that you need to consult legally. And this may happen for any number of reasons. It may be that you have a clash with your supervisor. I had a scenario in one situation where, so the scenario was I was leaving an agency and I was thinking about how to notify my clients, how to give them choice into what they did next and what the proper procedures were. And I was being told one thing by a supervisor, like, this is how we do it here. This is what you need to do. I felt that it did not entirely comply with client rights. And so for me in that scenario, I obtained legal consultation for someone whose background was in the field. Now, just like we are different professionals with different areas of expertise, lawyers have varying areas of expertise and information. So you can't just call any lawyer and ask their opinion because they may not have a clue. One mistake that non-legal folks do is they go look up a law and they're like, yep, right here, it says this. And so this is what I'm going to go by. And the reality is the way law works is it's not a law, it's a body of law combined with judicial practices, combined with how has it been handled in the past. And any one given scenario may pull in laws from 8 different things. So you really need to talk to a lawyer who has expertise in the area in which you are working. And one way to find that is to talk to your professional organization, talk to fellow colleagues and professionals, and then call legal practice and ask some questions. Most legal offices and lawyers will give you 5 to 15 minutes of time to discuss, here's my situation, here's my question, do you have somebody in your office that handles this? If they won't give you that much professional courtesy, you may not want to work with them. And if they tell you, oh, we handle every kind of legal problem, you definitively don't want to work with them. Just like with any other professional, you should be able to get some information about what their expertise is, what their practice patterns are, what their fee structure is, before you make a decision that, yes, you're going to go ahead and retain them and move forward and get a consultation as needed. And the last one, this is our superpower, right? Document decision-making powers or decision-making steps. Same is true for this. Years and years ago, I had a scenario where a parent reported me to the licensure board. And when the licensure board called and said, "What did you do here? I got a parent complaining about this. What have you done?" And I said, "I hear that complaint. This is where I disagreed with the parent." And then I was able to pull out my documentation. Was an actual paper, but it was on my computer, and said that, I contacted NASW Ohio. As a member of that organization, I was able to get an ethical consult. I actually ended up at a national level talking to an ethical expert there. I also called the licensure board, and I've asked a very concrete, specific question about time frame and deadlines, like how soon do I have to respond to this? So I said, I talked to so-and-so in your office and got this information. Again, I went through the steps of all of whom I had spoken to, how I saw the scenario, what I had done, how I communicated, and the process I went through. And he said, "You know what? I'm not even so concerned that you came up with the perfect answer as that you didn't do it off the top of your head, and that you clearly went through a process, thought through this, and asked some people whose knowledge base is different than yours." And so documenting is such a superpower, and I think we forget about that. And it comes in handy in other parts of our lives. So I know paperwork isn't everyone's favorite, and yet even in other everyday things, we write stuff down, dates, times, places, who said what, and when they said they would deliver. And boy, does that come in handy when someone disagrees, because you have that to fall back on and explain the process that you went through. And so that's very important too, especially if you're dealing with a significant ethical dilemma, that you show the process you went through and who you talked about. All right. So we're going to get a little more specific about some of the parameters to consider in making ethical decisions and in involving adolescents in those ethical decisions. So what are some of the parameters? We've already mentioned this, but how old is the adolescent? Different rules and laws apply to different ages. We often think about the absolutes. Here in Ohio, if you're under the age of 18, you're a legal minor. Once you're over the age of 18, you're a legal adult. Well, except for some things in which 21 is the age. But then it parses out in other ways. There's some places in states where at the age of 12, an adolescent can put some limits on their client record as to who sees it. And so how old your client is chronologically is important. And also, what is their developmental capacity? Because you can be 15 and have the emotional skills of a 4-year-old. You can be 15 and have the intellectual capacity of a 12-year-old. Or you could be 15 and in one very specific area where you've really had to manage, you could have the expertise and knowledge base that eclipses some adults, because you've been in a scenario where you have to know all of that. And so really thinking about how old is your client, and where are they developmentally is important as we consider how do we involve them, and even what's the ethical dilemma here. "11-year-olds are children pretty much in every sense of the world, every sense of the word. They still are fairly concrete thinkers. At this age, when you think about an 11-year-old, they can think ahead, but they often don't put together plans that hold water. So if you have parented this age group, you've experienced this. Child comes home from school and says, "Hey, mom, we're all going to go to the movies this weekend. So-and-so and so-and-so and so-and-so and so-and-so are all going to come, and we're going to go to the movies, and it's going to be great, and it's going to be awesome." They can think about what they want, but they're very concrete thinkers, and they often haven't thought through the details, like who's driving, who's paying, do you have everyone's contact information, are they allowed to see movies, or even that movie you're describing is R-rated and you're 11, so no. Or remember, we have the family get together this weekend, all of your aunts and uncles and cousins are going to be here, so no, you're not disappearing with 5 of your friends. So an 11-year-old often needs things spelled out much more concretely, and you often need to slow down. Not that you want to talk down to them, but you need to help them stop and consider all of the pieces, because at this age, they cognitively don't tend to step by step come through with all the specifics. So when we're dealing with an ethical dilemma, it's like, hang on a minute. This is what you would like and how you see it. This is what the law says and what your parents are responsible for. This is, my job, and these are my responsibilities. And here's the problem that we have. So how do we figure out a way that kind of meets most of those demands? And so this comes into play when 11-year-olds want to do things that parents are saying no to, or that we as this is an issue in foster care, where what do kids have right to do? What do foster parents have the right to give permission for? So how do we have kids have a typical childhood and balance out what does the agency say? What do the primary parents say? What do the foster parents say? What does the kid want to do? There's a lot of room for ethical dilemmas in there. And if we're going to involve a younger child, a younger adolescent, we need to help them understand these pieces. And I have literally drawn this out. I'm not a great drawer, so I'm pretty proficient at stick figures and arrows, but it allows them to kind of see the pieces of the puzzle and helps them sometimes understand that we're not saying no because we don't want you to do it or we don't want you to have fun, but this is what's allowed, this is what isn't allowed. And sometimes inside those parameters, can we make a decision, or can we help you make a decision about where to go from here? As kids get older and their knowledge base expands, their developmental capacity expands, they often are able to start to fill in those pieces themselves a little bit more. By 21, those same people are full adults. Puberty is mostly over, and society allows for and expects independence and responsibility. Each person is then responsible for in-depth problem solving and strategic thinking. However, if this is your client, there are still going to be things that they don't have life experience in. The later adolescents still can be overwhelmed by their emotional response and need help self-regulating before their capacity for judgment can, come into play. And if someone is, developmentally impacted. Either severe trauma has impacted their emotional self-regulation abilities, or they have a developmental disability that impacts their cognitive ability or their decision-making capacity. There are cases, of course, where a 21-year-old needs much higher levels of support to understand and engage in a decision-making process. And those can be really difficult ethical dilemmas when you're looking at someone who is legally an adult, but is in a dangerous situation and doesn't recognize or acknowledge it. And so I would argue that our ethical responsibility there is to help them process it at a level that they can understand and teach them skills to get themselves out of trouble. Because part of becoming an adult is making decisions, right? And suffering the consequences. So when you're dealing with the older adolescent, part of the, they may be in a position where, yep, that's your choice to make. You absolutely have that right. Can we take a couple minutes and think about what happens if that goes sideways? Because that will help them have the information and the knowledge they need to deal with that next step. Another framework to consider is, who is your client? This is a really important question to answer for yourself and often to clarify with the people that you are working with. So most professional guidelines and laws and rules focus around your professional responsibility to your client, which begs the question, who's the client? Is it the child? Is it the mom? Is it the family? Or as I said previously, I had one colleague I worked with or talked to, her client was the court system. And she had to explain to the families that she did forensic interviews. So she had to explain to the families that she worked with that this interview is not confidential. Everything you say to me can and will be reported to the court. I will be writing up everything we discuss, and it all goes to the court. And so her client, when it comes to client confidentiality, her client was the court. And I think that this is an important concept for us also to consider when we're dealing with other professionals. What if I'm the therapist for the child, but you're the caseworker for the family? And she's the forensic interviewer for the court. And he's dad's therapist, and she's mom's therapist. And this lawyer is representing who? Who's the lawyer representing? Because we can get together and there's absolutely need to collaborate and to coordinate and to share information. We need to stop for a minute and consider, who's my client and who's your client? And how does that impact boundaries? How does that impact how things go from here? So you have to be clear with yourself. You have to be clear with all the parties, and you have to be clear to the clients and their extended family members. Often on an ongoing basis. It's often not sufficient to just say it at the beginning. And so as a mental health therapist, if the child is my client and mom starts talking to me, I have had occasions where I've stopped her and said, remember, you're not my client. The rules of confidentiality apply to your child, not to you. Granted, there are boundaries there, but if there's a case that's going to court, everything mom says to me does not fall under the same level of confidentiality that everything the child says to me does. And that's where reviewing the rules and the laws and talking to professionals and sometimes consulting with a lawyer can be helpful to keep all of that in mind. what is your role? This is one where if you are at all subpoenaed, or if you testify in court on an ongoing basis, you need to consider supervision, possible consultation with a lawyer. And a resource for that is if you have your own malpractice insurance, you can also consult with them about any legal question. They would far rather answer your questions before court than deal with a hot mess after court. So for an example, expert witness versus forensic evaluator. And I will show you a partial quote of the laws in Ohio. And I'm not an attorney. Let's talk about boundaries here. I'm not an attorney. This is a partial quote. This is not the entire body of law. And you need to know the rules and laws where you work. But this is an example in Ohio. And Ohio's code has gotten clearer and clearer and clearer over the past 15 years. So a counselor, social worker, or marriage and family therapist shall not conduct a court evaluation in a case in which that counselor, social worker, marriage, or family therapist served in a therapeutic role for the client, his or her immediate family, or has had other involvement that may compromise their objectivity. This should not preclude a professional from testifying in the case as a fact witness concerning treatment. Licensees with a client involved in custody, visitation, or guardianship case, if asked by the client or the lawyer or guardian ad litem to make a recommendation about custody, visitation, or guardianship, shall cite their role as primary therapist for their client. This does not apply to a license hired to make a custody, visitation, or guardianship recommendation. Licensees shall inform their requester they have not performed custody, visitation, or guardianship evaluation, and it would be unethical for them to make any recommendation outside of their role as treating therapist. All right, what does that look like in plain English? So this was a section that I dealt with on an ongoing basis. So I was a child and adolescent therapist in private practice, which meant I ended up dealing with a lot of custody cases. So my role was the therapist, the treating clinician. What this little paragraph says, I'm in the therapeutic role. I am the primary therapist. Therefore, I could not make any recommendation about custody, visitation, or guardianship. I couldn't say, this kid would be way better off living with their healthy, regulated, got their act together parent A versus parent B who's struggling to hold a civil conversation with anybody, anywhere, ever. Couldn't say that. I could not say, yeah, I really think that they should spend most of their time with a grandparent who goes to all their games and brings them to all their therapy and participates in all their school. Those would be recommendations for custody, for visitation, for guardianship. Sometimes it's also called parenting time. I had easily 100 requests to write a letter to the court. Could you just write a letter stating that it would be better for them to stay at my house on the weekends that they had games because I live close to the school? Now, did it make perfect sense? Did I agree with that statement? Yes. Am I going to put that in writing? No, I'm not even going to say it. I'm not even going to say, I can say, I can see why that makes sense and how that might make life easier, but I'm not going to say, and the court should order that. When first time I wrote an ethics training, which was quite some time ago, I called the licensure board and said, what's the number one thing that social workers get in trouble for? And this was it. Writing a note, writing a letter, going to court, stating an opinion, even when the opinion is plain as day. Now, this first paragraph's last line, this should not preclude them from testifying as a fact witness concerning treatment. I have testified in court and said, this child is X years old. They have this diagnosis. They are being treated by myself and a psychiatrist. It is absolutely in their best interest that they continue on a regular basis seeing both myself and the psychiatrist, and that I would encourage a parent from keeping those appointments on a regular, ongoing, consistent basis. Those are facts. I can also state the fact, parent A brought child to 17 of 19 appointments scheduled by them. The 2 appointments they missed, one they called me in advance to say they had a schedule conflict and rescheduled it. The second time they called me that morning telling me that the child was ill and throwing up, and we canceled the appointment because the kid was sick. Those are the facts. Parent B scheduled 5 appointments, showed up to 2 of them, both times late. No-showed the other 2 appointments with unknown reason. And the 5th time showed up for an appointment at the right time on the wrong day. Those are facts. At that point, zip it up, turn a key, throw it away. I had an attorney say, so which parent should the child live with? I had to say, I can't answer that question. I am a primary therapist and cannot make a recommendation outside my role as treating therapist. My recommendation is that they continue in treatment and come consistently. Well, obvious which parent they should live with. Don't you agree they should live with parent A? And I said, I'm the treating clinician. I cannot answer that question. We had that conversation 5 times, literally 5 times. This attorney asked me that same question over and over again. And I just kept parroting back, I'm the treating clinician. I can't make recommendations about visitation or parenting time. Finally, the magistrate intervened and said, do you have a new question for our witness? So this is an ethical dilemma where you absolutely have to know what you can and can't do and what your role is. Now, if you look in the very middle of this, it says this section does not apply. So under line 1, halfway down, this section does not apply to a licensee hired to make a custody, visitation, or guardianship recommendation for the court. So I could be not for the same family. Once I've seen a family as a therapist, I can never be the person that evaluates them for court recommendation. But I could be hired by a different family, assuming I had training in forensic interviewing and in court recommendations. I could be hired under my licensure to do just that. But then it is ethically strongly discouraged that I am never their treating clinician. And if you're making a custody evaluation, you evaluate the child, you evaluate parent A, you evaluate parent B. And so it's a whole different process than being a treating clinician. So that if you're interested in that kind of work, you want to look for training on court recommendation or forensic interviewing, and how to find out more in your jurisdiction. So these are Ohio rules. And again, this is a partial quote. So don't ever go just on a partial quote. if I were wanting to get into that, I would attend a training specifically on that topic. I would contact the licensure board and ask, do you have information about doing this sort of work? A lot of times licensure boards will have a fact page or a fact sheet just so they don't have to deal with this stuff coming up the wrong way. If I were going to go into work that involved going to court on a regular basis, I think I would also speak to an attorney versed in this area and have them give me the lowdown of what should I avoid, where do people get most tripped up. And then again, your professional organization, if you are a psychologist or a social worker, it would be looking at, again, what are some fact sheets or information that might be applicable to doing this kind of work. Because you have to be very clear about the difference between a forensic evaluator and a treating clinician. And then you have to be very clear with your clients, the adults and the children, about, I can't do, and I've had kids say, can't you please just tell the judge? And I've explained in developmentally appropriate ways, no, I cannot just tell the judge. I mean, this is what I can do. I can help you write it. You write your own letter. I've advocated for guardian ad litems to sit down and speak to children. I've been supportive of children, but I can't go tell the judge. All right, what are some of the other parameters that we deal with in ethical decision making? Parent versus child rights. And we've talked about this a little bit as we've gone. And so parents and children both have rights and responsibilities. And often those are, in the background, running behind the scenes. Sometimes in an ethical dilemma or helping a family understand an ethical dilemma, we have to surface these very plainly. And so this wasn't so much an ethical dilemma as helping a child understand reality. I had a kid tell me that they weren't going to listen to anything Grandpa said because Grandpa wasn't their grandpa. Grandma had legal guardianship. Grandpa was married to Grandma, but did not have legal guardianship and was not the father of Daddy. So we've got child's dad, and then Grandma, who's Dad's mom. And that Grandma had legal custody. Grandpa was step-grandpa, but Grandpa was parent. Got the kid up, made breakfast, drove them to school. Grandpa was retired and Grandma was still working full-time. And so Grandpa was parenting. And so we very plainly discussed the difference between being a grandparent, being a legal parent, and someone who does the parenting, someone who does the work of parenting. And that, no, he was not a legal adult that she needed to listen to on that level, but that he was doing the work of a parent, and out of respect for the work and care he provided, that listening to him made sense. And this child was only 8. And I had to draw it out. Like I had to diagram it. As you see me using my hands, I have to diagram almost everything. But I had to draw this out for this kid. And they finally agreed, because they were like, well, I shouldn't listen to him because he's not my daddy's daddy. And I'm like, well, he's not your daddy's daddy. That's not the reason to listen to him. Listen to him because he's doing the work of parenting. And what are the jobs of a parent? Food on the table, roof over your head, being safe, being taken care of, Band-Aids when you get cut, knowing what you like to eat and don't like to eat, like one of the issues, the kid finally went, oh yeah, when I have toast, he knows not to get the grape jelly because I don't like it. I'm like, great, that's the job of a parent. They know what kind of jelly you like. They go to the store and they buy the right kind of jelly and they put the right kind of jelly on the table. That's the work of a parent. So out of that comes the respect and the listening. I was like, oh, got it. I'm like, I told the adult later, I'm like, the jelly won the case. They were like, what? And I'm like, I don't know. There's logic and then there's kid logic. So sometimes we have to surface parental rights, child rights very concretely and put it out on the table for ourselves, for the children, and even for the adults, as we kind of pull apart an ethical situation. And then you have to layer in your location and the rules. So California, for example, allows certain records to be kept confidential from parents starting at the age of 12. So 12-year-olds can ask that certain records be sealed and never shown to their parents in the state of California. So you have to know your own state's rules and regulations. That is not the case in Ohio. There is no 12-year-old rule in Ohio. So one aspect of ethical work is to be as transparent as possible with all parties about what are we looking at here. Confidentiality is, I think, one of the most frequent ethical dilemmas that many of us face, because there's that balance between sharing information so that we're all on the same page and we all know what's going on, and maintaining confidentiality as required by law and as just an acceptable ethical responsibility and a boundary for that adolescent. I see this as really a really important territory with adolescents. 6-year-olds often assume you're going to tell their parents everything, or 6-year-olds will be like, Mom, I'm not going to tell you about the time I hit that kid. Like, they blow their own cover all the time. But by 14, there's things they don't want you to tell anybody. And so discussing confidentiality is really important. And I invited adolescent clients to ask me all the time, do you have to tell someone this? Or I would see them hemming and hawing. They're like, well, something happened. And I would just say, are you thinking about confidentiality? Are you thinking about whether or not you can tell me and where that information will go? And so this was one of those things that we surfaced all the time and that I discussed very transparently. And other times, I clients, if we could come to a compromise and find a way to tell a parent something that I felt was important or that was important to them. I had a 13-year-old girl who was in extreme distress. She would not tell me what was wrong. For about 3 appointments, she finally told me what happened, swore me to secrecy. It was not a safety issue. The next door neighbor had offered her a cigarette. Like, what 13-year-old hasn't had the next door neighbor offer them a cigarette? I'd like to meet the one. And so I was like, really, after all this agonizing? But the issue was the kid swore me to secrecy. And I said, this isn't a safety issue. Your neighbor offered you a cigarette. You said no. They haven't pressured you again. And the neighbor was another kid. Like, it wasn't some adult offering them this. It was another 13-year-old. Like, there's no imminent risk there. But there was a psychological concern, is that this kid could not stop thinking about it. They were obsessed, and it was disrupting everything because they were ruminating on it. And they were afraid their mom would find out and afraid what she would do. And finally, the compromise we came to was said, I think you need your mom to know. Let's talk about how we can tell her. And I gave them a couple scenarios. You can tell her here, you can tell her at home. I can tell her. It might be better coming from you. But I felt like we needed to kind of break that tension. Finally, client decided they would write their parent a note, put it on my coffee table in my office, leave the room, have me bring the parent in. And as the kid said, you can handle her reaction. Mom comes in, kind of worried. This huge secret is finally going to come out. Mom's half crying, even though I've told mom, no, seriously, if it were a safety issue, I'd have told you by now. I can't not tell you a safety issue. It's okay. Mom finally flips this note over, reads it, and her reaction was to burst out laughing. And I'm like, shh. She thinks you're going to be upset. You can't just sit here and like laugh until you cry, or you can, but you have to do it quietly. Mom's like, you've got to be kidding me. This has been a month of stress and anxiety and big, deep, dark secrets. And it's nothing. I'm like, okay, but she thinks it's something. So we had to give mom a minute to laugh and to regulate herself. And then we talked about what she was going to say and thanked her kid. And you can tell me anything. And so that was sort of a backwards ethical concern, in that I had no right to tell parent, and yet I felt the kid needed to tell parent. So we found a way. This is a huge one to figure out who are the legal parents. And this is where, if you are not sure, consult. Because making a mistake about this in the beginning of a case can really cause trouble down the road. And parents don't always understand this. Like, I have had parents not understand their parental rights. So you, as the professional, need to understand the parental rights, even if the parent doesn't. So knowing who the legal parent is important. And so looking at the image on the left, we have two dads. And in some states, same-sex parents can be listed on the birth certificate having full and equal parental rights. So you have two dads, they have full parental rights, they're the same. That is not true in every state. And it may not be true in a relationship where one parent has a child and then a step parent joins the family. And they may be equal parents in terms of emotionally, financially, time, all of that. But understanding who is the legal parent and to what extent is super, super important. Now, in the case of a same-sex couple where a state doesn't allow it, it's obviously a delicate or sensitive topic. And in some of those cases, the parents have done paperwork to allow the parent who's not the full legal parent as much legal responsibility as they and their lawyers can figure out how to do without a judge ordering that person to be the full legal parent. But it's important for you to know, and again, it depends somewhat on the work you're doing, but this is where you have to know your jurisdiction and you have to get information from the parents. The image on the right, what if the grandparents have custody of the grandchildren? So in Ohio, permanent legal custody can be granted to a grandparent or anybody. But that does not sever full parental rights for the biological or the first parents. Those parents could still request visitation or parenting time. Their full parental rights aren't severed, which is different than adoption. In adoption, full parental rights are severed. The biological family, even if it's an open adoption, even if all one big kumbaya and everyone goes to Thanksgiving together, the first set of parents whose parental rights were severed are legally strangers to the child. They are not legal, they have no legal right. And the adoptive parents are full legal parents as if they gave birth to this child. And so can be a really complex area, and in certain scenarios and cases, it can take your ethical dilemma and just shoot it right through the roof. So one of the scenarios that I would see on a fairly regular basis, at least a couple times a year, is a legal parent who's been absent for one reason or another, shows back up in the scene, calls my office and says, I'm so-and-so's dad. I want to come to the next therapy appointment and I want a copy of their records. And I call the parent that I've been seeing and say, hey, I've heard from this other parent. And they're like, oh, he hasn't been around for years. He doesn't get access to anything. I told him to go away. Well, I need to see the paperwork. When in doubt, slow down. Ask for documentation. And if needed, get your own legal consultation. I have taken custody papers to my practice attorney and said, what actually does this say? So examples, a parent can lose all rights to visitation without losing right to access records. And I'm not sure, I had one judge explain it. I asked one judge, I'm like, so this parent is not allowed to see this kid, spend 5 minutes with this kid, but they can request records? And the judge said, well, yeah, I mean, they have the right to know if their kid's going to school, what their grades are, if they're seeing a doctor, got any major health problem, because the behavior is not so egregious that I'm willing to permanently sever rights. And the only way for them to kind of get back involved in this kid's life would be to kind of see how things are going, find a way to establish communication and get involved again. And that would start with, just basic records. Second one I refer to, parents retain certain rights, even if guardianship of their child is given to someone else. One of the most common ones there is that they have the right to request visitation or parenting time. If a step parent adopts a child, full legal adoption, they are now the legal parent, even if a biological parent still sees that child from time to time. And here's where states differ too. Some states have legal open adoption where the biological parent is given certain rights that have to be respected. Ohio is a state that does not legally have open adoption. So I could adopt a kid. I could tell the biological parent, I'll send you a letter and a photo every single year. I promise. And then I could decide for any reason of my own that I don't want to. I'm not gonna. That biological parent could go to court and say, she promised me. And the law in Ohio is like, well, she's the 100% the parent. If she's decided she doesn't want to, she doesn't have to. There's nothing you can do about it legally. So it's really important to know who's the legal parent, what does it stand? And I have seen custody papers confusing enough that I've had to have an attorney look at it and tell me, what really does this mean? And how does that impact the work that I do? And then helping parents understand it or kids understand it. Again, within reason, I'm not an attorney. So if it gets contentious, then you refer it for them to go speak to their own attorney. All right. So what is your ethical frame of reference? Again, knowing your own ethical frames is important. So this is the ethical frame of reference that I work through. The NASW Code of Ethics is the one that I have to focus on when it comes right down to it. We've talked about law. And the fact that it isn't law, it's laws. That S is so important. Laws are multifaceted. They are important. They're also sometimes outdated. So one area where laws are outdated and really, really difficult is around technology, where a collision happens. Technology, adolescence, and sexuality. So 2 adolescents in a relationship sexting one another, particularly if they send images, violates, again, depending on the state, pornography laws and child victimization laws. And so then you get kids who are judged to be in violation and found to be a sexual predator, which is a far cry from what actual sexual predator behavior looks like. And so one thing to be very aware of is that you have these frame of references in mind and know what applies to you and what applies to the scenarios that you most often deal with. So these are some Ohio rules. At 14, teens can give consent to outpatient mental health treatment for 30 days or 6 sessions without their parents' knowledge. As I said, in California, at 12, adolescents conceal certain records. But there's complexities to this. So at 14, they can give consent to outpatient treatment, but who's paying for it? In reality, where this actually occurs is often in a school-based, grant-funded mental health treatment, where a high schooler, for example, could see a clinician for 6 sessions where the parent isn't billed. It doesn't show up in an insurance statement. And there's no imminent risk situation, because that's another set of law and another set of rules that's going to be more important than this specific rule of not telling the parent about treatment at all. Another Ohio example, at 16, teens can consent to sex. This is a mistake where I've had adolescents look up the law. And as I said, it doesn't do any good to look up one line of law and make all of your judgments based on the law says this one specific thing. So I have had this conversation with multiple teenagers where they have they've looked up Ohio Revised Code and they're like, look, I can make my own decision. And it doesn't matter how old the other person is. I can date this 19-year-old and have relations with them. And there's nothing my parents can do about it. And that's where we pull in the, well, wait, your parents have other responsibilities and there are other laws that impact this. So while this specific, very narrow range of behavior you can give consent to, there are curfew laws. So one of the towns that I practiced in often had a curfew law that during the school year, children under the age of 18 had to be home or accompanied by a legal guardian at a certain time of day. There's also all the laws and rules around school attendance and parents' responsibility to ensure that a child is educated. There are also laws and rules around contributing to the delinquency of a minor. And so I'm like, well, while this one specific line item of behavior may be acceptable, your 19-year-old friend could get in trouble if they have you out over curfew, if they break any of your parents' reasonable and standard rules, which could be something as simple as you have to do your homework before you're allowed to leave the house. that's your parents' household rule, and they help you circumvent it, they literally could be charged, conceivably, with contributing to the delinquency of a minor. This is an issue that we often unpacked in some detail with teens, that yes, they have rights. They also have responsibility. Their parents have rights and their parents have responsibilities, and that everyone has to operate within certain boundaries. And when trying to discuss this with a teen, sometimes the best way to do it is to not talk about them, to talk about a friend of theirs. Because what I found interesting is I would have an adolescent just outraged. My parent is so ridiculous. They make me blah, 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 blah. But if I could reframe it, what if you had a friend and their parent didn't make them blah, 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 blah? What do you think of that parent? So often the answer was, oh, those are irresponsible parents. Their kids are going to be in trouble. Their kids are going to fail school. Their kids aren't going to do well. Why would a parent let somebody do that? Do you hear yourself? To helping them unpack it, helping them see all the pieces to the puzzle can prevent an ethical dilemma in the first place, because we can work together and compromise. The other one, in Ohio, at no age can a minor teen decide which parent they choose to live with in a custody hearing. And that used to be different. And I forget now exactly what the age was, but there was at one point a law that said at X age, a child could state, I want to live with this parent or that parent, and that was the rule. It's not the case anymore, and part of the reason for it is the scenario that I kind of described, where a parent lets a kid get away with everything. Sure, you can have your friends over. Sure, you can have alcohol. No, you don't have to go to school or clean your room or eat healthy food. You can just live however you want. And then there were kids who were like, well, I'll live with that parent. And so the reasoning behind no age at which a child, someone under the age of 18, can simply decide is so that they're not put in a position of being manipulated by a parent, or sort of bribed by a parent, or choose a living circumstance that is not as healthy for them, for their development in the long run. It also takes them outside of having to make the choice, because that's a terrible position to put a kid in. And again, I think ethically that's a place for us, is to realize we don't even want to ask that kid, who would you rather work with? Because that puts them in a loyalty bind, which is a very, very painful place to be. And said it's our responsibility as adults and professionals to hear them out, to explore pros and cons, to consult with other professionals working on a case, and to help make decisions that take into consideration the desires or the wants or the wishes of the adolescent, at the same time that you take into consideration the rights and responsibilities of the parent, and what in the long run is most likely to work out best. And so thinking that through in the long run. All right. The other thing to think about when you think about age of consent is, if you're working with adolescents over time, they may cross over some of these thresholds while you are working with them. So let's say you're working with an 11-year-old in California and they turn 12. What does that do to all the records that existed when they were 11? In Ohio, if you're working with an adolescent and they're getting close to that 18 year, you have to stop treatment and have all of your intake paperwork signed now by the 18-year-old. Because now they are their own legal representation. And so paying attention to ages of consent and the thresholds in your area of practice are important, because kids have birthdays and they change in age, and it can be helpful in some cases to start that conversation in advance. So I had a scenario with an adolescent with major significant mental health disorder who at times would, the mental health issues would become so huge they'd end up hospitalized. And they said to me, well, what happens when I'm 18? And we explored power of medical attorney for psychiatric reasons for when they turned 18. Because like they had an incident where they were 17, meds quit working, and then they quit taking meds, and they ended up in a very dangerous, unpredictable, unstable mood state. Parents had to intervene against their wishes, force them to go into the hospital, get meds back in line, get emergency treatment, get back on their feet. And then by the time they came back to me, outpatient therapy, we talked about how angry they had been at their parent at forcing them to go to the hospital, and how vital it had been that they went to the hospital. And the client said to me, wait a minute, what happens when I'm 18? I'm like, it's a lot harder. It's a lot harder to force somebody to go to the hospital. When you were 17 3/4, your parents could just say, because I said so, and I'm your legal guardian. And they could mandate some things that were against your wishes. That is a lot harder to do with a legal adult. And they said to me, well, that's scary, because this happens to me like every 2 years. I would want my parents to step in. And so in that scenario, we talked in advance about the differences between a minor being required to get treatment by their parent and an adult needing it and having their own rights and responsibilities. And with the adolescent's consent, we brought the parents in on the conversation. We had a whole family conversation. It was a couple sessions, because they were justifiably worried about what would happen in the long run. And then they ended up consulting an attorney and drawing up paperwork so that the parents could evoke legal rights to ensure power of medical attorney in the event of a psychiatric emergency for their adult child, which ended up happening 3 years later, when this person was in college, and the college called the parents and said, you need to do something. They're in a bad way. And parents had to intervene and pull out the paperwork against their then adults' objections, and essentially repeated the cycle. They were able to use that paperwork, require them to go into treatment. They ended up hospitalized for a while, got stabilized, actually ended up coming back to me for a little bit because they weren't ready to go back to college. And we had the same conversation about how furious they were, how pissed they were at their parents at the time, and how grateful they were down the road. Because who knows what would have happened if they had kind of been on their own in the adult system without anyone having any authority to step in, who knew the scenario, knew their medical history, knew what meds worked and didn't work, had been through this before. And so thinking about ages of consent down the road, either for yourself or helping your clients think it through, is another ethical responsibility. And if you're working with adolescents with significant developmental disabilities, where there's the potential that a parent would need to have full legal guardianship, which is very different, being the full legal guardian of an adult with disabilities is very different than being a parent. It's much more spelled out. There are limitations. And I recommend parents start that journey when their child is 16 or 14. I'm like, don't wait till they're 17 and a half to figure out how guardianship rules work in your state, because you won't have time. You'll be overwhelmed. There's too much to unpack. So I often recommend that by the time high school starts, parents should be looking into, don't we need to consider guardianship once this child turns 18? And even then, if someone goes from being parent to being legal guardian of adult, you're going to have to redo all your paperwork, and you're going to need copies of the guardianship. You can't just act like, well, you were their parent until they're 18, and now we'll just keep going on the same path. At that change in age, you have to reconsider all of your paperwork as well. So again, looking at all the policies and the procedures about all, paperwork, intake documents, informed consent, all of that, and anything that has to do with, your client's rights, adolescents' rights. And we're entering an era in the world of social work, and I know NASW is very actively involved with this, that laws are being passed that contradict our ethical responsibilities to tell clients their full range of options. And so one of the ones that immediately comes to mind is there are places where departments of education are stating that if a client tells you that they wish to go by a different gender marker or a different name, that we're required to inform the parents. That is a huge ethical ball of wax that is just now starting. And I can't sit here and say, here's what you should do about it, because we're just entering that phase in our current social political world. And I don't have solid answers for now what. And I don't think there's going to be a solid answer for this is what you do in every case. Depends on your profession, depends on your responsibilities, depends on the policies and procedures, depends on the law. There are going to be a lot of room there for, humble, ethical decision-making and processing. I think a lot of room there too for informed consent, explaining to adolescents how things work, giving them information so they can make informed decisions about what they do and they don't share. Timeframes, that's another thing that immediately comes to my mind. What if there is a rule? What is the rule? Is it the minute somebody says something to me, I pick up the phone and call somebody? Is it 30 days notice? Is it like, what does this actually look like? And some of you may be in a position where you're helping wrestle with just exactly that. Well, here's the rule, here's the law that's come down. What does that look like in our policy and procedures? How do we handle it in-house in compliance with the law or the rule, considering ethical guidelines? And that absolutely, if you're writing policy and procedure, particularly around things around the law, I definitely would be running that through an attorney. And I would guess in this day and age, you'd have to hunt for an attorney who's done enough work on it to be able to give you a solid answer. I would argue that trauma-informed care principles are good ethical guidelines. SAMHSA has just released policies on implementing trauma-informed actions with clients. So it's a huge 51-page document with recommendations. And I argue that this informs ethical decision-making when we take into consideration, particularly all of us in the helping professions, the rates of trauma history in our clients, in the parents of our clients, in our colleagues, and even in our own histories, are higher than the average general public. So we know statistically that people who are in need of child welfare services, in need of mental health services, in need of all the other mental health professionals often have higher rates of trauma than the general public. Therefore, exercising trauma-informed principles in our work with our clients provides a higher level of ethical care. And so the first principle, safety, is both ensuring somebody's actual physical safety, finding ways to elevate a sense of emotional safety or psychological safety. And this is simple things like don't walk up and touch people without being sure that they're okay with that. It can be the way you come into a room asking permission to shut a door, asking if they need a break. It's paying attention to people, and if they all of a sudden look really uncomfortable and go really still when a topic comes up, stopping and offering them, are you okay? Is there something you want to ask? Just something you want to say? Like paying attention to how people are feeling in the moment. In working with clients around trauma, making sure that you're teaching people some grounding skills and that you do it with them, so that rather than just barrel ahead and just keep on plowing forward, even when someone's overwhelmed, that we stop and take a minute to let them ground themselves, us ground ourselves before we move forward. The next one, trustworthiness and transparency, I've been talking about with these ethical principles, that when possible, when we're dealing with an ethical dilemma, we put that out on the table. And we say, I kind of have an ethical dilemma here. Like, I want to protect your confidentiality. Confidentiality is really, really important, and you have every right to that. And at the same time, I feel like you would get better services if this other person or this other party knew this information that I have. How do we protect your confidentiality and get that information out there in a way that is helpful? A very specific example of that is I worked with clients who had IEPs or 504 plans at school. So an IEP, an individual education plan, or a 504 plan, which comes out of the American Disability Act. So they had plans in place at school that pertain to their mental health diagnosis. And there was information that I knew and that my client knew that would be helpful if they were in crisis in a school setting. But do they really want all their personal information out there told to every teacher? Because I've seen it done that way. I have seen it like, okay, this client has an anxiety disorder, and when they have a panic attack, these are their triggers, and this is how to calm them down, and this is how often they happen, and this is what they look like. I've had that email sent to every single teacher that student or client has in class. And a lot of teenagers find that super awful and cringeworthy. And there are some teachers who are not that supportive, or who don't get it, or who don't understand it. And so how do we protect the client's confidentiality and get the information into their school setting where it might be of most use? And the workaround that I've used most often is talking to the adolescent. Who do you trust in the building? Who do you actually go to anyway if you're having a panic attack? And the answer to that varies. Oh, the librarian's really helpful. My homeroom teacher is great. I go to my tutor. I go to guidance counselor. Well, there's one vice principal. And the flip side, I never talk to the nurse. She's mean. I can't stand my homeroom teacher. Oh, that's the principal that yelled at me, right? So figuring out who they go to and who they don't go to. And then saying, what if we picked 3 adults to be your contact people? I want at least 3, because you don't want 1 or 2, because that's the day they're in a conference, they're out of the building, one's on vacation and the other's got the stomach flu. So my minimum recommendation is, let's pick 3 adults that you trust. Let's tell everyone else that if you're struggling, that they're to send you to or reach out to one of the 3 trusted people. And then let's just share your personal information with those 3. Let's not send it to everybody in the building. So there's a trustworthy, transparent, we need to get this information out there, but you help me choose who gets it. And then we just refer everyone else to those 3 people. It also makes it way easier to keep people up to date. If there's been a medication change, if there's been a symptom change, if there's been a change in what works and what helps and what doesn't help, we can go there. We can just update 3 people instead of the entire building. Peer support, mutual self-help, another trauma-informed care principle. And this is asking the adolescent, are there other people that help you? Are there people that you can talk to? Making sure that they're not just relying on adults, or that they're finding somewhat older adolescents or young adults who can be there for them. And then again, dealing with that whole confidentiality issue of who shares what. I think collaboration and mutuality has been the theme of this whole, like, as much as possible, let's involve the adolescents in solving the problem. They know stuff we don't know. Nobody can tell you their entire life story in the short amount of time that you've known them. So when you run into a problem, often there's a missing piece of information that only the adolescent can tell you. So collaborating with them, working together with them to solve the dilemma, whenever possible, can be important. Same thing with empowerment, voice, and choice. Presenting them with the options as you see it. And I think stating it that way. These are the choices as I see it. That humble attitude of, I am not the expert of the universe. I am not omniscient. I don't know everything. I have laid things out in front of adolescents and said, here are the choices as I see it, only for them to be like, well, or we could do this, or we could try that. I had one issue about informing parents that was on that borderline of needing consent, not needing consent. There were certainly some safety concerns, and the teens' perspective was, yeah, we can tell my mom, but let's have grandma come too. I was like, really? How come? She goes, oh, because that's who calms mom down. Like, mom calms me down, but grandma calms mom down. So if we're going to tell mom, we're going to tell grandma. I would never have thought of that. Again, knowledge I didn't know. Although as soon as they said it, I was like, oh yeah, I've heard mom say, oh, I had to call my mother. So I know this about the family, but I didn't like piece it together. And then cultural, historical, and gender issues. Taking a giant step back. And when we think about ethics and we think about a person's perspective on power and control and who gets to make the choices and who's in charge here anyway, are there cultural, historical, or gender issues between you and the adolescent, between you and the family, with the court system, with other people involved? Again, being transparent about those is part of what's making this whole situation difficult. Something that has to do with racism or classism or sexism, that might be better surfaced rather than leaving it as the elephant in the room that we're just not going to talk about. And so that's a whole nother set of frameworks to consider. All right, that's a lot, right? So in your handout is this page, a giant picture frame, my frame of reference. And so, you know, I encourage you to stop and pause for a minute and think about your frame of reference. Particularly, where do things clash? I've done this workshop live with people, and there are certain sticking points that some professionals are like, oh yeah, all the time. And, you know, parental rights versus child rights is one of them. Often sticking point in child welfare. I've had parents talk about, or I've had professionals talk about the rights of, you know, self-determination versus a client who is in a congregate care setting and have strict limitations about what they can and can't do. You know, parental rights to visitation versus a setting limiting visitation based on a client's behavior and working their way through a point system of earning visitation. So there are some ethical conflicts that happen on a pretty routine basis. And then there's others that are more, you know, once in a blue moon, doesn't happen very often. If you have something that's happening over and over again, that may be where you want to escalate it and put some pieces into place so that you have policy and procedure. And been there, done that. We've already talked this through, and this is our policy on that. That certainly was my case when it came to parental rights to accessing records. I would talk in the very, very beginning of counseling and state, here are the rights. If a child is under the age of 18 in Ohio, the record, so all the counseling, you know, information is owned by the parent. On the other hand, you have brought your child to therapy so that they theoretically have a third person to talk to, a safe space, a confidential space, a private space to process all of their thoughts and questions and concerns. What is your attitude about accessing those records? Not that you have a crystal ball and know for sure where things are going to go, but what's your intention? And I've had that conversation out loud in front of the adolescent so that an adolescent knows. And I had one dad say, oh, I want the complete record every month. Limits that adolescent being able to tell me anything and everything, but it also protected that adolescent's right to personal privacy and confidentiality. I've had other parents say, no, I want them to feel free to talk to you about everything and anything. And I don't intend to ever access records. And what I have said to parents, I said, you know, you can always ask for partial records. So I had a court case, I had multiple court cases where parents wanted to prove that they were the one bringing their kid to therapy. And I said, so you just want an attendance report. You're not asking for the notes. You're not asking for the complete record. So I would have them put in writing. I would like to know, I would like an attendance report of when my child came to therapy, any appointments that were, you know, missed or canceled, and who accompanied them. I wrote those reports often and without hesitation because that's just the facts. You know, January 17th at 2 o'clock, you showed up with so-and-so. And I would sometimes offer that even as a compromise. So for me, that was a clash that happened all the time. All the time. And so I ended up, as part of my intake procedures, surfacing that as a very concrete, here's where I've run into trouble, here's how I handle it. You can ask for this kind of report instead of a full record. That made life much easier going down the road. So again, you can pause this and think about, where do you currently have, routinely have, or see coming down the road ethical clashes? And where might you go for more information about how to handle that? In working with adolescents, I feel like this is a primary clash. Is that one of the ethical codes of conduct for NASW is self-determination. And I think one of the most important things is being really, really transparent with the adolescents about their choices and the potential consequences of their choices. I had a scenario in which a 16-year-old told me that they were going to run away from home because they had been online and they had found a modeling school in New York City. And there was a 6-week modeling class that they could attend. And so their parents had told them no, they could not go. And their intention was to go anyway. Wasn't quite imminent risk, but we were pretty darn close because they felt like this client was desperate. And they stated as such, like, I have to do this. This is my future. I'm going to be a model. Without this class, I can't be a model. And they said some more things that I was like, that is straight out of the marketing material you've been reading online, like 100%. But they were firmly convinced that this was their goal in life, and this was the only means to achieve it. So, full transparency. What is likely to happen if you run away? First of all, how likely are your parents to figure out where you went? Pretty high. So he then decided that my job was to convince his parents to let him go. And I said, but I can't guarantee that. I can, here's what I will promise. I will not promise that I will get your parents to let you go to New York City. Mind you, this is an Ohio born and bred kid. I'm from New York. I don't think a kid brought up in Columbus, Ohio is ready for the streets of New York. I'm not about to promise him that I'm going to convince his parents that they should drop him in the middle of New York City for 6 weeks. But that was my business, not his business. I said, I cannot promise you I will talk your parents into this. I will promise you that I can help your parents understand how incredibly important this is to you and how much you see this as central to your identity and your future. He's like, well, all right. So we did that. I had him explain it full depth to me. I explained to his parents that at his stage of development, he literally was like, this is it. This is my future. This is where I need to be. This is what I've got to do. This is how important it is to me. I had his parents explain how they felt about it, what their concerns were. And then we met all together, and I told the parents that they needed to tell him what they understood about how important this was to him and leave their concerns and their questions and all of that off the table. Just really, really explain to him what you understand about how much this matters to him. And they did. They did a really eloquent job. And it took about 15 minutes for them to in depth. And I asked him to just listen. And when they were done explaining how important it was, he was all but crying. He was like, you get it. You get it. You will understand. And I said, okay, now here's the hard part. Even though you understand, Mom and Dad, what is your answer? And they said, our answer is still no. He was like, I didn't see that coming. And then I asked him to listen again, and we explained, our parents explained, I tried to keep my opinion out of it, their responsibility. But at the end, and the risk and the fact they didn't have $2,000 to send him to 6 weeks of modeling camp, practicality was last on our list of things to worry about. So he felt heard and he didn't run away. And then we talked about, but where do we go with this? This is incredibly important to him. And we discussed other options, and I asked him to do some homework. I asked parents to do some homework. I asked a friend of mine for some info. Turns out you can do some modeling in Columbus, Ohio. It's not so exciting. It's modeling for, the local grocery store that sells clothing. It's modeling for local companies that sell paper towels, but you can do some modeling. You can get a headshot. You can start to build a portfolio right here in the safety of your own town and with your parents knowing who you're with and what you're doing. And it doesn't cost $2,000. In fact, you could make some money and put it away for future college or coaching or whatever, down the road. But, there was this self-determination allowing him to really explain. But the look on his face when he was like, they understand, and they still said no. I did not see that coming. Was, I don't know, I think adolescence in a nutshell. He did not expect that. But it avoided a huge dilemma on my part in that I then did not have to worry that he was going to run away, and I was going to be the one that knew where he was going or knew that he was going to do it. So, communication strategies. How do you communicate about ethical dilemmas with your clients and the other people that you're working with? And sometimes, sometimes things are happening and they feel really urgent, or someone is dysregulated, or someone is demanding. One of my ethical dilemmas was a parent literally banging on the counter at my office, insisting, I own the legal record, give it to me now, throw it on your copy machine and print it out. So it felt in the moment very urgent and very demanding. One plus is I knew and was able to remember, I have 30 days. I have 30 days, and record releases have to be done in writing. And then I have 30 days to comply. So you can't storm into my office, pound on the desk, and insist that I hand you the record right this very minute. So that's where reviewing and knowing things that come up on a regular is really, really helpful. I was, again, able to tell that parent, I hear you. I understand how important this is to you. I get that this matters. Like, I'm going to validate all of your concerns and validate your request. And yes, I will comply with a valid request. However, I also have rights and responsibilities. Let me get to that. And so I asked him to put it in writing. I gave him the 30-day notice. I pointed out that he'd already signed that when he filled out the intake documentation when his kid was first there. And then I took advantage of those 30 days to explore some of the other parameters and options in that particular scenario. So very rarely are things quite as imminent or dramatic as it feels like it. I've gotten subpoenas in the mail. Your heart rate goes up, your breathing goes up, and you're like, ah. And again, it feels really urgent and really overwhelming. And I don't know what I'm going to do with this. But you have time. It is not imminent. Truly imminent things, like this person has an incredible medical emergency going on. You don't have a lot of time to think, but you don't need to think. Like, this is a 911 situation. We're not a lot to think about here. I had someone in my office having a clear medical emergency tell me not to call 911. No, you can have that argument with paramedics. Like, they were, it was an older grandparent who was having a stroke and didn't want me to call the squad, wanted me to call their primary care physician. Like, yeah. Nope. You can argue that with the paramedics. I will call the paramedics right now. And then you can argue with them. But I'm not gonna wait around. So we've talked about this. Consider the youth's decision-making capacity and legal age. So we're gonna bring it all together. What do they know about the situation? I've asked adolescents, what does confidentiality mean? And I've had kids say to me, well, it means you're confident. Nope. I mean, yes, I am, but no, that's not what that means. And I can see why that word would make you think that. And then I've asked clients, what does confidentiality mean? And they've read me chapter and verse. They know exactly what it is. What is their capacity for long-term thinking? Can they walk this scenario out? What will this look like down the road? Like that older adolescent who started to think about, what if I have a psychiatric emergency after I'm 18 years of age and I refuse help and I need help and my parents are the ones that know and I tell them to go take a leap? Like, she had really good long-term hypothetical thinking. And in her case, the risk was high. So her decision-making capacity was great. Legally, she could not sign any document to give her parents consent until she turned 18. So what they did in that scenario was they consulted an attorney, they drew up all the papers, and on her 18th birthday, they stopped by the lawyer's office and signed the paperwork because she couldn't legally sign the paperwork at 17 and 360 days old. She had to wait till she was actually 18 to sign the paperwork, but she could help create the documents before then. And so there was a case where she had long-term thinking. She had hypothetical thought. She knew the risk was significant. And then another ethical issue in terms of adolescence is, now we aren't doctors. We don't prescribe, I don't prescribe medication. I don't recommend the medication. I don't say, oh, you should try this, you should try that. Or I've had clients who've worked well with this, but I have worked with families in regard to how far should a parent go in insisting, demanding, or forcing, say, a 17-year-old to take their medication. Not that I'm deciding what the meds are, more I'm advising the parent on, like, if they won't take their meds, do I take them to the hospital and insist that a hospital staff give them meds? Do I have consequences for it? Do I let them make that decision? At what age do I start making that decision? And so this is, again, an ongoing conversation. And where I start with is kind of around the experience in long-term thinking, is a lot of clients that I've seen in particular have been on meds since they were 9, 10 years old. Now the client be like, I hate my meds. What do you want? I don't know, blue pills and white pills. What do you hate about them? I just stupid. I hate that I have to take it. What are they for? Well, I've been taking them since I was 10. And I realized that a lot of adolescents refusing to take medication were hitting an age where self-determination was important to them. They were working on their self-concept. Am I the kind of person who needs meds? Does this mean I'm sick? Does this mean I'm crazy or I'm abnormal? These are all things that they had every right and need to talk about and explore. And what are you diagnosed with? How did you get it? What does it mean? What are the meds supposed to do? What are the meds not supposed to do? What is the side effect? And so here, to me, this is starting at adolescence into, because at 18, they can be like, yeah, I'm done. I'm not taking any of it. So I think ethically, when kids start complaining or refusing to take meds, we have a responsibility to start to engage with them about, what is your diagnosis? I have ADHD. What's that mean? I'm hyper. No, really, what does it mean? I don't know. How did you get the diagnosis? How do we come about that? I have re-diagnosed kids, like gone back through the diagnostic process with them as more active participants than they could have been when they were 10. And you talk to 10-year-olds and they're kind of like, can I leave now? Certainly 6-year-olds. But by 14, 17, they're like, and then they're watching TikTok videos about it and YouTube videos about it. So it's important, and I think ethically responsible, to unpack it. What is it? How did you get it? Why do you have it? Where did it come from? Will it go away? What are the meds supposed to do? What are they not supposed to do? How do you keep track of your side effects and your symptoms? Are you talking to the doctor? Does the doctor listen to you? I've done this with a child too, with diabetes. I don't know, they make me take my meds. They don't give me a choice. And the mother's like, there's no choice. There's no choice. And I'm like, okay, first of all, when there's 18, there's going to be a choice. And they're going to be a lot safer and healthier if they understand what we're talking about here. So educating kids, explaining, asking questions, answering questions, listening for understanding, listening for long-term thinking and hypothetical thinking, talking about risk, and starting to transition more of the right and the responsibility to them. Again, within that risk issue is big deal. Well, if they don't take this particular med over the summer, they're going to be grouchy and their friends are going to be annoyed. Is that a risk we're all willing to let the kid take? In the end, the parents have legal responsibility. Kids have rights. We don't have any authorization over medicine, so we can't really say. We can only help them broker that decision. Versus they'll go into diabetic coma and end up in the hospital and be really, really, okay, it's a whole lot more risk. What do we need to do to help the child understand? Never say this, blah, 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 blah. You understand that, right? What does your client say? Yes. What do you say when people do that to you? Oh, so, glad you're here and blah, 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 blah. You got that? It's really awkward to be like, hang on, wait, what? I don't understand what you just told me. I've been to doctor's appointments myself. We're like, well, you're going to see this person and that person and then this and then blah, blah, blah. And it's awkward to be like, wait, I thought I was seeing Dr. So-and-so today. Is that? I didn't understand all of what you just said. And they're like, no, you're going to see the doctor, but you see this person and then you see that person, and then you're seen by the doctor. Got it. Thank you. Don't put your clients in that awkward position of having to look stupid and ask, I don't know what you said. So instead, I would explain things and ask people to say, sometimes I talk fast. What did you get out of that? What do you understand about that? Once I hear it back from them, then I know we're on the same page. And I just said this, prevent concerns. So the confidentiality is one piece. I also asked that question once, well, what does it mean that things here are confidential? And I had a kid say, I could kill somebody, bury the body, give you a map, and you're not allowed to tell anybody. And I was like, well, I am happy to report that that is not the law. I am allowed and required to report safety issues, both you and other people. So if you kill someone or tell me that you're going to kill someone and mean it, this is what happens. So I started my appointments with, what does this word mean to you? Sometimes it saved us time. Sometimes it gave me some insight into my client. This other one, adults in custody cases, often I found believe that what they told me in session was 100% confidential, even from the guardian ad litem. And that is not true. If the child is my client and a parent tells me, yeah, I supervise them really good, except weekends when we all get totally drunk, but that's okay. They've learned to be a good little bartender. That is not a confidential statement. If a guardian ad litem sends me a subpoena and says, tell me about the parenting style in this house. Again, I can't make a recommendation about who this kid should live with, but I can report conversations. And being a good little bartender as something that I might feel that a guardian ad litem needs to know. The other thing is, don't overpromise. Can be tempting. I won't tell anyone. I've had clients say, I have something to tell you. You promise you won't tell anyone? I can't promise that. In child welfare, when will I get my kid back? When will I move back home to my mom? I don't know that. And I'm not the decision maker in that. Oftentimes you're not the decision maker. Here's what I do know. Here's what I can tell you. But not over-promising or not over-delivering things that are outside your ability to make happen is important. Sometimes assessing the situation with the client. So the case example, you want me to release your child's records, which you have every right to in their entirety. But you told your kid that counseling would be a safe place for them to talk. Would it work if I gave you a summary of their goals and their treatment history? I've had that request from parents where they're wanting to get an IEP for a child at school, and the school is requesting information about therapy. Like, you don't need the whole record. What you need is, what's the diagnosis? What are the treatment goals? And how are we working towards them? Because that will help inform the IEP. That's all the facts that you need. That would help protect your child's privacy, confidentiality, and meet your objectives to advocate for your child. And that's the thing. Parent isn't trying to violate their kid's boundaries. They're trying to advocate for their kid on one hand, and they're trying to maintain confidentiality on the other hand. And a lot of everyday ethical conflicts are that kind of, these are both good goals to strive for, and they're clashing with each other. So slowing down, checking for understanding, don't overpromise. Document, again, I said that earlier, but you want to document the process. Should something ever come up for like ethical review, like these are the steps that we're taking, this is how I consulted, even somewhat about your decision-making thoughts. Engaging the adolescent in the decision-making, keeping in mind their, their developmental ability, their cognitive capacity, their understanding, and what they can add to the situation that maybe didn't occur to you, like the client that's like, let's bring grandma in on this. Look for that compromise and acknowledge it in writing. So for example, I had a parent fill out that request for records. So they give me a written request, and the written request said, I want my child's entire record. And I went back to them and said, okay, what are you looking for? How much information do you need? Okay, you really just need treatment goals in progress. I document that in writing and either send it in an email or have the parent acknowledge it in writing that they've amended their request, so that they can't later come back and be like, I asked for the record and she didn't give it to me. I can document, you asked for the record. We had a conversation about just exactly what you needed, and this is the compromise we came to. I had one scenario where dad wanted the full record, mom wanted nothing released. Dad was worried mom would take it to court against him. He was worried that mom had the whole record, so he wanted to have like equal information. I was able to clarify to both of them, I haven't given either of you records. Do you just want an attendance report? And do you want me to assure you that if I ever send either of you anything, you'll both get the same document simultaneously? That was the compromise we came to, because both had brought the kid to counseling. So I wrote out an attendance report with goals in progress and a part of statement that if any further records would be released, any parental request would result in identical records going to both parents, whether or not they requested or not. They both signed it. Now that was the case where the dad was pounding on my counter, wanted the whole record, wanted it immediately, and made a board complaint against me. By the time I'd sorted all this out and the board came in to figure out what was going on, I said, nope. We have a compromise. This is what happened. This is who I talked to. This is what we came down with. This is what I did. And they're like, great. And that's where he said, I don't even care so much what your decision was as that you consulted and had a process. And so they closed the case. What are some barriers? Being exhausted, being tired, being overwhelmed, being rushed, having impaired decision-making, like confirmation bias. Is really easy to say, don't make any recommendations for parenting time until you've been a therapist for a kid that you really care about. And one parent is a complete jerk, and the other parent is always supportive. And you really, really, really want that kid to go live with a supportive parent. And you've got a strong bias going. And it may or may not be correct. But that's where you take 2 giant steps backwards. Think about your professional role and responsibility. Consult with others. Talk about some of that transference that's going on. And understand what the limitations are. Because it's really easy to say, do this, do that. But in real time, when you're standing there in court and you really have an opinion, you do not help your client by going outside your lane, because then your entire testimony gets thrown out. And the other barrier is the flying solo. I got this, I know what I'm doing. I'm an expert on this. I've handled this before. I got this. No. Consulting and thinking who you can talk to is important. starting with making sure you understand the dilemma, actively listening to the scenario, what's being said, what's not being said, thinking through what are you being asked to do and does this make sense? And we talked about consulting with a lot of different people. Like, this is where my recommendation very strongly is to take one of the last pages on the handout is some communication strategies, some questions to ask yourself, ideas for plans, and your resources, like developing on an idea list of who would you contact before you need them. Like, do not wait until you're in the midst of a really difficult decision, stressed out with more stuff going on than you're quite sure what to do with. Like, take this opportunity now, even to contact someone that you know and say, hey, I just took this ethics training, and one of the recommendations is to have somebody to consult with. Are you willing to be that person for me? And I'll be that person for you. You know, I have a colleague who also is LISW. When I was seeing clients, she saw clients, we saw the same age group. And I had asked her, I said, you know, if I need someone to bounce an idea off with, are you willing to be that person for me? I'll be that person for you. So we'd already set up the parameters and even talked about logistics, like, you know, what are we talking? Are we talking 20 minutes? Are we talking an hour? Are we talking, you know? And so we had a conversation about what would work, what wouldn't work, what our schedules look like. And then it became easy to reach out to that person and say, hey, I have a 20-minute question for you. I have a 5-minute question for you. Or this is an email. What was that lawyer you were talking about last time we talked? Because I think I need to escalate this. So my suggestion is that you build your list of who might you talk to before you even need to talk to anybody. So looking at, you know, those procedural standards of care, and thinking through, where do you go for this information? So resources at work, your supervisor, a colleague. Does your organization have an ethics board? Most hospitals have an ethics board. A lot of larger agencies have an ethics board. Smaller agencies may have a committee or just sort of an ad hoc group that will discuss ethical dilemmas. Do you know? Ask around, find out now. Professional organizations. I know National Association of Social Workers has ethical review at both the state and the federal level. So if you're a member of NASW, that's one of your benefits. You can call and say, I have an ethical review I want to do. The licensure board. I have called the licensure board with a question. I also know that people can call the NASW board, and the NASW will call licensure, so that there's like 2 steps removed. If you're worried about confidentiality. If you carry malpractice insurance, you can often access legal through your malpractice insurance in a before this stuff hits the fan kind of a way. Like, I want to do a consult and I got a subpoena. What should I do about this? You can contact an attorney. And I just spoke to someone who is a forensic interviewer, and she had a really difficult case. She called her malpractice insurance company, explained the scenario to them. They put her in touch with an attorney, and the attorney said, you need representation. They're pushing you hard to step outside your professional boundaries. So we're going to have an attorney in the courtroom representing you. And she goes, every time an attorney asked me an inappropriate question, my attorney would be like, excuse me, my client can't answer that. Excuse me, my client can't answer that. Here are the guidelines. Excuse me. Okay, that question my client can answer the first part of. Go ahead and answer the first part. She goes, it was amazing to be in this courtroom with all this legal stuff going on, knowing this, I had this person literally over my shoulder, standing up for me and making sure that I didn't cross any lines so that my testimony would stand and would make a difference in this case, and that nobody could come back on me and say that I'd done it wrong because I had representation. She said, I didn't know that was a thing. I want to tell everyone. And then other times, talking to a practice attorney, certainly if you own your own business, your legal structure, your intake paperwork, all of that should be reviewed by your own attorney before you go into practice with that as information. And a lot of these consultations won't give you the answer. They will give you guidelines. They will give you suggestions. They will ask you questions. Often in the end, it's up to you, and sometimes you and the client, to come to an agreement that's effective. So again, you have the handout, and there's a question on, develop a plan going forward. And the first question is, what are your cues that you have a concern? How do you know you're facing an ethical dilemma? A lot of times it's that sinking feeling. It's that, oh no, I think I just made a mistake, or I don't even know where to go with this. What are your most common barriers? You get tired, the demands of your job, the pace of work. Is it that you don't have people to bounce ideas off of? Do you hold biases? I mean, asking, this is part of where really good supervision can make a difference, and that you start to become aware of your own personal biases. For example, I have been divorced. I am a mom. So I knew that one of my biases that I had to be aware of, particularly when my children were younger and I was closer in proximity to the time that I'd been through a divorce, was that I was very prone to be biased on the side of mom with kids. And I had to know that and realize I couldn't believe all that I was hearing, and that I was only getting one side of the story. And also have a strong bias that parents or kids benefit from having all of the healthy adults in their world, in their life, and making sure I balance it out with that. But just knowing that was really important for me in terms of making sure that I stayed in that middle ground, and that I was advocating most strongly for my client, which was generally the child. If you have things that are kind of pop up on the regular, it can be important to take time to prevent those problems in the future. The issue of being asked to write letters about parenting time was something that came up often enough that I amended my intake paperwork and put a section in there that said, these are the rules, these are the guidelines, and that I would not under any circumstances be making recommendations in writing or verbally about parenting time, visitation, or custody. And that was something in my intake paperwork that I had a special little box for, and I needed an initial for. And that was interesting because it was happening so often that I was being asked, and sometimes really outright pressured. Now, I really need you to do this. That I put that in my intake paperwork with the help of an attorney. And there were some clients who got there and went, wait, that's what I wanted you to do. And I'm like, I'm a therapist. I'm not a forensic evaluator. It's not how this works. And I had some clients not come back. And at first I'm like, wait, I'm losing clients over this. And then I'm like, oh no, I'm not really. I'm not getting started with the people who shouldn't be my clients in the first place. So I can't see it as a loss. I'm wanting to be working with the people who want me to be a therapist to their child, not a referee in their divorce. And therefore, I'm not losing clients. I'm weeding out those people who I are better off not working with. So that helped me prevent problems down the road for sure. Other times policies or procedures can be put in place to help. How can you communicate more clearly to your client and to their parents and to the other professionals? Again, if you're tripping over common things, it may be time to take a giant step back and have some clearer communication. In a previous training, one of my participants said, you know what, where we need communication is my agency needs to talk to this other agency. She said the problems we're running into over and over again are not really me and the other professional. It's the policies for our agency and the policies for their agency put us in untenable situations. And she goes, I just realized this is not my problem to solve. And so she's like, we need to escalate this. We need to look at these two agencies who are working together on a regular and ongoing basis, understand and clarify policies and procedures so that we're not constantly dealing with this situation. And it's like, yeah, that the problem doesn't lie with you and your ethical practice. The problem is lying at a higher level. And then thinking through, what are areas that you might want to learn more about. And so if you look at your handout, the back page has a list of resources. So there's information about adolescent health rights, Alliance for Children's Rights, the Child Welfare Information Gateway, cyberbullying. There's ethical principles and standards on research. So if you are engaged in research at all, there is a whole body of ethical standards and guidelines around involving children, so adolescents, in research study. And again, that whole concept of informed consent, like who are we informing and whose consent are we getting? In research, the highest standard is that we both inform the legal guardians and get their consent, and that we inform the subjects, so the adolescents, and get their consent. So very high standard for doing research. Guttmacher Institute, I talked about. The Juvenile Law Center has information on how to elevate youth voice and how to really involve them as full partners in decision making. And then whatever your professional organization is, they all have their own guidelines and restrictions. So I thank you for participating in this. You have your multiple choice test to complete, and I wish you all the best as you move forward.